Our next speaker is Professor Danielle Friedman, Professor Emeritus of Law at the Tel Aviv University. He's a member of the Israel Academy of Sciences and the Humanities, member of the American Law Institute, and a member titular of the International Academy of Comparative Law. He was also an advisor to the restatement third of the Law of Restitution. He got many prizes, including the Israel Prize for Legal Research, and he also has a very, very distinguished career as a public intellectual, op-ed writer, and a person involved in public life. He served as Minister of Justice in the year 2007 to 2009, and he publishes many op-eds on many positions of public affairs, current public affairs. He is kind of a provocative voice in Israel's legal community, and his most recent book is a comprehensive and challenging book on the relations between legislatures and courts in Israel, and he will talk to us about rebuilding the relations among the powers of government in Israel. Please.
Okay, thank you, Professor Gavison, for the introduction, and I will talk about the separation of powers in Israel. Now, it is one of the features of democracy. One of the features is a suspicion against government power. This is typical of the idea of democracy. While it is recognized that governmental power is essential, actually, for the well-being of the community, to advance its ideas and ideals, and nevertheless, it is recognized that there is an apprehension about the use of governmental power. There is a kind of a suspicion that this power may be used to advance personal interest of the groups in power or the persons in power. It may be applied to oppress rivals and the groups that are not so much liked by the governing groups. And then so the question is how to address the issue of having governmental power on the one hand and restraining it on the other. Now, in a sense, democracy has already an inherent mechanism for such containment of governmental power, and that is the election. The very fact that the political parties must account to the public every 4 years or every 3 months, as it happens to us, requires a certain restriction, because they know that if they go completely wild, it may affect the result. So this is one kind of a break or a check on the way they conduct their affairs. Another means maybe simply that there is a kind of line of thought that maybe it's better to restrict governmental power altogether. If we look, for example, at the American Constitution, the Second Amendment speaks of the right of the people to bear arms and keep them. Now, what is the idea behind this? There can be various interpretations, but one of them actually says, well, we don't want too strong a government. We don't want the government to be the strongest player, the only one that can protect us. The government, we can afford to have a weak government, a weaker government. We should keep the arms. We, the people, we will have the arms, and we can protect ourselves. Now, I don't think that this idea proved very beneficial or very efficient, and I think I now turn to the main concept actually dominating this thinking, and this is the idea of separation of power. The basic tenet tenet, I think, that one can say about democracy is that power should not be concentrated, or governmental power should not be concentrated in one hand or in one institution. And this goes back, of course, to Montesquieu, and he spoke in almost extreme terms. He says that when the legislative and executive powers are united in the same person or the same body of magistrates, there is no guarantee of liberty. And similarly, he says, there can be no liberty if the judiciary power be not separated from the legislative and the executive. That is, we need separation of power. Now, if we look at the law books or at the theory about the way that the Israeli system functions, one can conclude that the government or the executive is extremely, extremely powerful. There's hardly any similarity in democratic countries. And I shall now start really with the executive, which is defined by the legislator in basic law. The government is the executive authority of the state. And as I say, in theory and in the law books, it is extremely strong. We have a parliament, but it's only one house. And the parliament is, in a sense, almost controlled by the government. That is, the government must have we hardly ever had the minority government. The government controls more or less the parliament. So we have the executive and the legislative united in one body, and the executive is extremely powerful. There is no constitution that limits it. So we have the executive is, one can say, almost too strong for a democracy. But this is the theory. The reality is the very, very opposite. The Israeli executive is extremely weak, despite what is stated in the law books or in the legislation, despite the theory. First of all governments in Israel are coalition governments. This means that it is never one party that controls the government and parliament. So the major party or the major parties must come to terms with smaller parties and compromise. They can't do what they want, and very often they have to give in to the smaller parties. In fact, the reality is that the smaller parties very often have disproportionate power relatively to their size, and this system actually was highly beneficial to the religious parties, which enabled them greatly, notably the Orthodox, greatly to increase their power in Israel. So this is one aspect. The other aspect, which is at least as important, but maybe even more important, the question is, who is the executive? Again, we look at the statute, the basic law, the government is the executive. But who controls the police? Who controls the prosecution? Actually, very early in the development of the state, we did a number of things. First of all, it was decided that the prosecution will be completely independent and entrusted not to the Minister of Justice, who is a political person, but to an appointed person, the Attorney General. Now, the government has no control over the prosecution. The idea was, of course, that the government will not use its power to pursue political enemies, to prosecute them or to bring them to trial, etc. But what happened is that this power, and this is a huge power, and I said it's one of the most important powers, governmental powers, the power to issue or to initial criminal prosecution. Now, this is entrusted to an appointed person who is, in many respects, completely independent of the government. Another body that is of the utmost importance is the police. Who controls the police? Who can send a policeman to stop me in the street? Can the government do it? Again, the answer would be no, definitely no. The government has the power to appoint the controller general, or let's say the person, the head of the police. But from that on, and also they have a number of powers relating to appointments in the police. But beyond this, nothing. In fact, the dominating figures are the Attorney General on the one hand and the Commissioner General of the police on the other hand. These are dominant figures in addition to a number of police officers responsible for investigation. So the police can start any investigation they consider proper. Sometimes they are prompted by the Attorney General, but the government can do nothing, except that they can file a complaint like any other citizens can do. But in their position as government, they cannot cause the police to start investigation against X or Y and so on. So this is another chunk of the executive power that is not really in the hands of the government. But then who appoints officials in the whole public sector? We have another group. In addition to the police, to the prosecution, another group that is very much independent of the government. And this is the public sector bureaucracy. Rather early, again, early in the state, it was decided that we don't want political appointments. So a whole machinery was set in order for people to be appointed in the public sector by way of public tender and so on. So they are, in effect, appointed by the bureaucracy. That is, the bureaucracy appoints itself. So again, the government, if you consider what the government can do, and we say that the executive has the sword, the government controls the army. So far as, let's say, defense against foreign enemies or attacks or okay, thanks. Thank you. The government is in control, but so far as the internal system is, in fact, the government has relatively little power, and much of it has been transferred to independent officials that have been, some of them are appointed by the government, and in some cases they don't even have the power to appoint them. Right now we have a struggle over the appointment of the state attorney, or the one to replace him, between the Minister of Justice and the Attorney General, and like anything else, it is likely to be ended in the court. And now we go to another stage as to what happened with the judiciary. As I say, despite what is written in the law books, the government is extremely weak. And the fact that it is a coalition government, and it's so difficult very often to secure a coalition, and notably as a result of a number of failure of the politicians, and right now we have their failure to form a government, this relatively weakness of the government enabled the legal machinery headed by the Supreme Court to greatly increase their power. And although we don't have a constitution, At one stage, the Supreme Court held that the Basic Law entitles it or empowers it to review parliamentary legislation. So parliamentary legislation is now subject to judicial review. But actually, the court does much more than this. In fact, when we ask who legislates in Israel, everybody would say, Parliament, Knesset legislate. Look at the law books. It's written in the law books that Parliament is the legislative body. But if you look at the law book, or as the statutes, you will get a very partial picture. Because the Supreme Court became a major legislature. There are many things that happen right now are actually the result of the Supreme Court legislation. To give just one simple example, which everybody meets, right now, the country has been paralyzed for almost a year on the ground that a temporary government is not allowed to act. If you look at the basic statute, the basic law says the very opposite. It says that it doesn't use the term temporary or caretaker government, but it says that such a government has all the powers of ordinary government. Indeed, one example that I often remind of is the appointment of the former state attorney, Dorit Beinish, to the Supreme Court. She was appointed, and this happened just 20 years ago, she was appointed during the time of a caretaker government. Nobody thought that there is a problem with this. However, some 8 or 10 years later, the Supreme Court legislated, and I wouldn't like to go into the circumstances that prompted this legislation. They legislated, by way of an obiter, that during a caretaker government, there must be extreme caution in any action, including appointments. From now on, we can't appoint. So if you ask, how is it that the country has been paralyzed for 1 year? The answer, this is a result of judicial legislation that affects everybody's life. And that's how it is. And the government can do very little, or did very little, or felt that it was unable to do. And this is the situation with this result. And this is one example. And I'll give you an example of another piece of legislation, also dramatically important. One day, an indictment was filed against one government minister, his name was Deri, and a vice minister. Now, they both had immunity, and this immunity was not yet removed. While this was pending in Parliament, an application was made to the Supreme Court on this matter that the Prime Minister will fire them. Now, the Prime Minister Rabin, has at the time his own consideration, because the party headed by Deri at the time was crucial for him for the purpose of the Oslo agreements. So he didn't want to fire this minister, and there were very heavy political consideration really to keep him, in fact, not forever. It was agreed that he would be kept until his immunity is removed. But at least for some time, nevertheless, the courts decide that he is forced to remove him. And indeed, in an earlier lecture we had from Professor Dotan about the power or the control that the court or the legal machinery assumed over appointments and over positions in the public sector, both elected and non-elected. And this was one of the, I think, one of the stepping stones to this occurrence. Now, in the course of this decision, the court also held that, first of all, the Prime Minister is not entitled to be represented in court if the Attorney General disallows them. I don't think there's any country in the world or any court in the world that would dare to decide that the Prime Minister is not entitled to be represented. But if we look at the Israeli system, this is what the Supreme Court ruled. Is this human rights? What that is I would say nothing is further from human rights than this kind of decision. Is it a powerful executive? Is the executive powerful? The poor Prime Minister is not entitled to be represented in court. The one who supposedly represents him, the one whom the Attorney General sends, actually comes to court and say to the court, take the opposite. Don't accept the Prime Minister. Go against him. Issue an order forcing him to fire the minister, the head of the other party. And that's not all. In addition, now the court says that the opinion of the Attorney General is binding upon the government, which means that although he is defined by statute as an advisor, all of a sudden we learn that an advice is a command. He is commanding. And so we look at it, and there is a concentration of power, and there is a concentration of power of the executive, but it is not in the government. The concentration of power is in the Attorney General. I would mention an article in a newspaper by Professor Shlomo Avineri, who said, I don't know if I translate it correctly, enough concentration, or maybe meaning, or it would be more correct to say too much concentration. And he says that the Attorney General in Israel has more power than the President of the United States, the President of France, or the Prime Minister of Britain. So there is a concentration in the executive, but who is the executive? Not the elected parliament, not the elected... Okay. Thank you. Not the elected government, but some kind of a, well, very important official. He is the executive, not elected by the people. And now I think the major challenge, and I would just add briefly, in addition, we have powers of the executive also allocated to various agencies. We have an agency on the capital market, and we have other agencies on, or the same agency regarding insurance companies and banks and so on. And these agencies, actually, in theory, part of the executive, they have broad executive, legislative, and judicial powers, but they are not controlled by the government. The government can hardly intervene. So, in fact, what remains in the hands of the elected executive is relatively small. So I will now come to the challenge, which is towards the end of my talk. I had a number of hints in this direction. How are all these independent bodies to be controlled? Or in another way, if Montesquieu says there is nothing as there's no liberty if judiciary power is not separated from the legislative, one must remember that the court has enormous legislative power. At the same time that it adjudicates a case, it can decide and promulgate a law that will apply to this case. So this is a kind of a unique combination. And if we look at the whole of this picture, we find that enormous powers, legislative and executive, has been entrusted to non-elective bodies. And the question is how, and they are in a sense outside the whole system of separation of powers and checks and balances in the separation of powers. And if we ask the question of challenges to our democracy or to democracy, the question is what kind of controls do we have over all these bodies that have enormous powers and that drastically affect our life and affect human rights. There is one issue that I cannot go into in details, but I would merely mention it, and that is the deplorable situation in criminal law in Israel. The position of persons investigated or brought to trial in Israel is really deplorable, and as in many other countries, we have all the plea bargaining, but in addition to this, they have relatively very little rights. Now, who is going to protect their rights when the legal machinery is the power that is actually depriving them of their legal rights? That's, as I say, the main issue that that should be confronted by liberal democracy, by Israel, and that is the control of all these powers that has been transferred to non-elective bodies, including the court. Thank you. לא רוצה לתקן, אם מישהו רוצה לשאול, לא, גמרתי לפני הזמן. Yeah, I hope the audience will not be very cross with me because I ended a few minutes before the so yeah, okay.
If you want to have a quick question for Professor Friedman, that's a good time. If not, we'll move on.
Yeah, I think we can. Yeah.
Okay.
So how is that not a direct result of the absence of a comprehensive constitution?
Well, the absence of constitution did not prevent the court from acquiring more and more power, both the court and the legal establishment. That is notably the Attorney General, which is perhaps the most important or the most powerful personality in the Israeli legal system. The absence of constitution had no effect on this specific matter. The Supreme Court acts as if there is a constitution. You can answer whether this is justified, that it acts as if there is, but it does. And this is the present situation.
What I meant is that shouldn't this be defined in the Constitution, the checks and balances? And in the absence of definition of checks and balances, you can pay.
Well, one could, I mean, it's important to have it in a constitution, at least as a matter of practice. I think even ordinary legislation can deal with some of the issues. For example, the excessive powers of the Attorney General, I think, can be dealt with in ordinary legislation. However, here we come into politics, because right now we have a pending indictment against the government, so you'd find that the opposition is very happy about the power, or what I think the excessive power of the legal machinery, and they will support him. And at the time that the government is not extremely strong, because it doesn't have the majority, now it's very difficult to deal with these matters. At the time they could deal, they didn't. That's another matter.
Thank you very much.